You too. Tone. I'm back with another one for you today. So this one here is a continuation on common law abatement. And we're just going to get right into this one. So right here, again, from one, corpus juris, objection to jurisdiction, right? So you have a lot of options as far as the art of war and shit like that, but initially, before arraignment is when you're going to be able to do a common law abatement, and this is just going to be before you even get to the facts and anything like that. What's happening here is that you're fucking addressing the clerical errors that essentially invalidate their whole claim to begin with because it was not addressed to the right person, right? So a nature of pleas to the jurisdiction. A common law pleas by which objection is taken to the jurisdiction of the court are not strictly pleas in abatement but are in a class by themselves and are designated as pleas to the jurisdiction. They differ at common law from pleas in abatement in several respects, as for example, in that they must be pleaded in person and not by attorney, and in that they must conclude not with a prayer for judgment of the writ or declaration, or of the writ and declaration, and that the same must be quashed, but whether the court will or ought to take further cognizance of the action or suit. So if they're even going to recognize it or hear it. So you're going in as a special appearance, and essentially when you go in as a special appearance, it's not a usual appearance, so you're not going to be under any risk of whatever the fuck it would be if it was a regular hearing. And so it's simply to address the possibility of any remedy and or what options that the court does have available for remedy or settlement and closure and shit like that. Or if it's an issue like this, special appearance is going to be to address the clerical errors and shit like that, right? So apparently they want that shit done in person, or you can mail it in, right? Which we're going to get into too. So they are, however, dilatory pleas. So dilatory just means to fucking basically stretch shit out like they like to do. Have 1,000 fucking court dates for one fucking case. Why don't we just deal with that shit today? You know what I mean? I'll tell you why. It's because they make bonds on every fucking date that they get out of you. It's a new bond for them to sell, as distinguished from pleas to the merits, right? So dilatory would be a plea to waste time, apparently, and then distinguished from pleas to the merits, speaking about their clerical errors and shit like that, essentially canceling out their fucking merit in general, and that their effect is to defeat the present suit and not to deny or bar the cause of action, and therefore they are in modern practice treated for most purposes like the other dilatory pleas or pleas in abatement, which is what this would be as well, and are subject to most of the rules governing such pleas. The following is an excerpt from an article by James Hazel titled The Abatement Process. Also, James' article note about deceptive all capital letter names, which is fucking Roman. I mean dog Latin, excuse me. The all caps is not English. That shit's a whole other language, and it means something else. In written form, the following example to be delivered to the court clerk or judge confirms with Randy Lee's successful petition and to the requirements for abatements as enumerated in corpus juris secundum, and many cases which have treated the subject of abatement for a misnomer. So a misnomer is to use the terms or words in the wrong way. So that would be if they were to use the English language incorrectly, which is what they do when they use the all caps. That shit is not fucking English. So that's a fucking problem. That's a big problem, actually. So, and then here we have, this is useful for instances where you have the opportunity, as in most cases, to reply in writing to a written demand or summons, because then you can default them right into your own judgment, right? They start sending you fucking summons and stupid ass shit like that. You can literally default them into your judgment using common law and certified and registered mail, and that is court. And using a clerk's, what is it? The fuck is that called? Damn, bro, it's late. I'm fucking. A fucking notary. So using a notary and shit like that as your personal magistrate, right? A magistrate, mad guy, you're doing the magic. And these fucking assholes will feel that magic when you start sending in that paperwork and shit. They know what time it is. So, as it's much simpler than appearing in person, and most people prefer this option. Of course you would, because you don't have to deal with these dickheads. And you got to be careful, because when you go in there, essentially you're in their fucking jurisdiction, because they only have jurisdiction on their docked vessel, which is inside of that building. That's why they always drag you to fucking court and shit, and they want you to go to court, because then they can fucking, you know, play with you, fucking scare you and shit like that. They can't do that from your house, and they have no jurisdiction in outside of their fucking building. They don't have any, you know what I'm saying? Like, these motherfuckers like to act like there's some type of kings and queens and shit. They're only the boss inside that building. As soon as they step outside of that building, they're in the real world, and nobody can save them out here. Nobody can save them out here. So, the First Amendment, petition for abatement. 2, the fictitious name of court expressed in all uppercase letters. The address of the court, including the zip code. So, from petitioner would be you, right? Properly capitalized, mail received, care of, United States Postal Service address, including the zip code. You put care of because you don't fucking reside anywhere. You're sending it into the care of. So, or just make it clear that you're using it as a mailing address, not as a residential address, because the term resident is a commercial term, and so you don't want to use that. Inhabit or domicile. Regarding complaint, demand, or accusation number, right? So that's going to be whatever the stupid case number is, attached hereto and thereby incorporated as an integral part of this petition for abatement, comes now. John Allen Doe, the live man, by authority of the first article of amendment, AD 1791, to the Constitution of the United States, to petition this court to abate the above referenced accusation complaint on the following grounds. Number 1. The accusation complaint against John Doe is a fictitious name, was delivered into my hand on date, as a prudent man who fears that his ignoring of the instrument might. So let me switch this slide. So, fears that it might well result in coercive procedures being used against him, right? Which is what they do, right? You fucking ignore this stupid little fucking summons, and these assholes think that they can come kidnap you on the fucking street because of a fucking administrative error, right? What the fuck is that? What the fuck is that about, bro? What the fuck part of the game is that? So I have chosen to approach the court with this petition that the court abate the instrument so that it cannot in its present form further restrain my liberties. Number 2, that the instrument was served on or delivered to me as evidence that this is a case of misnomer, which is them using the wrong fucking font, the wrong language, and sending it out to the wrong person that looks a lot like you to try to fucking convince you that they're talking about you, right? And they're making fucking demands and shit like that. Oh, really? How's that from a fucking charter corporation registered in Britain, bro? Yeah? Making demands? Or mistaken identity. The instrument is against a fictitious name, John Doe. My given Christian name is John, with the initial letter capitalized as required by rules of English grammar for the writing of the names of natural persons. Right? And these motherfuckers want to start using different languages and shit like that. When you're over here in fucking America, bro, guess what you're going to be fucking using? English, motherfucker. Do you speak it? My patronymic family surname is Doe, with the initial letter capitalized. The accusation complaint does not name me as the party. Number 3. If the complainant or accuser has any claim or argument against me, it can bring a complaint or accusation against my real name to the real live living person. They can't do that shit. They're not even allowed to fucking speak to you. That's why they send you letters with fucking fake names that look like yours, trying to make it seem like they have power that they don't fucking have. Right? This is how they're fucking tricking you. So my objections herein will make it possible for the complainant or accuser to issue a corrected writ, which is the primary purpose of the matters in the abatement. Number 4. This is by content, ground, intended, and definition is a petition in abatement and not a plea in bar. So the bar is British Accreditation Registry, just so you know, and that's British law that they bring over here with their private membership associations called the bar, right? And they're all just private members of that gang, essentially, is what it is, the bar association, which brings fucking British law over here somehow, and may not be construed as a motion for dismissal or for mere amendment of the instrument. It may be justly resolved and only by abatement by the court. When a petition for abatement is before a court, that court is charged with, according to the defendant petitioner, the benefit of the doubt. In addition, courts should take cognizance of the law that provides where conditions for its issuance exist. Abatement is a matter of right, not of discretion, meaning that it's not up to them to fucking decide if you can do it or not. It is what it is. The same thing as a writ. This is what kings do. You write writs and shit like that. Like, we hit your bonds, we don't fucking sue you. You know what I'm saying? And this is how we do it. Why the fuck would I ask you if I can sue you? It doesn't work like that. When you're the fucking public servant, you have a bond there for when you cross the fucking line and them shits get taxed. Really that simple. So this misnomer or misdescription of a party defendant is ground for abatement, and grounds for abatement are the same for equity and law cases, right? Because everything has to be fucking proper there, and that's why you got to check the paperwork when they're sending it to you. You're always going to find clerical errors because they do not have the authority to fuck with you at all. So they're always going to fucking try to trick you with language and shit like that, playing fucking stupid ass fucking childish games and shit. That's what the fuck do these faggots do. Just know that. So further, I say it not, except to advise the court that in the absence of abatement of the instrument as a restraint against my liberty, I shall henceforth remain mute. Date, right? And this is how that's going to look there. And so if anybody needs this shit too, just send me an email. And my email is found in the about section. Don't ask me questions in like the comment section and shit like that. That shit is crazy. That shit is crazy. Look in the fucking about section and you'll find my email there if you have any questions or if you need something. So when a demand is abated, it can theoretically be refiled properly, naming the accused man or woman, right? And that's an easy case too, because then you're going to question their fucking authority in general, because they don't fucking have that. So most demands prosecuted in court contain other fatal errors besides mistaken identity of the accused by use of all uppercase letters in their entitlements or captions, and by erroneously, which means that they do it wrong, capitalizing the term plaintiff and defendant, right? And it's going to be little things like that. That's why fucking attention to details where you're going to find these assholes, because the devil is in the details. Really is. And fucking devil just means to deviate, right? Devious, devil, deviation. They're deviating from the norm slightly in different places to fucking trick you into their nonsense. They fail to identify the parties, the venue, including the names of lawful states and counties, and the name of a lawful court. It is advisable to avoid the shotgun technique of trying to cure all defects with one abatement petition. It's preferable to focus on the first, and that's what you should do too, because then they're going to get tired of fucking dealing with you. So just correct the name first. Boom. They'll send it back with the plaintiff and fucking defendant capitalized. Boom. Hit that shit again. Send that shit back. And then start sending them a fucking invoice and shit like that too, because they want to be playing fucking stupid games like you have an obligation to entertain them for free. You don't have to entertain these assholes for free. So send this shit along with your fee schedule. Get your fucking estoppels in place and shit like that too. So you know what I'm saying? It's gonna cost them more to fucking play stupid ass games than it is to just go fuck with somebody else. You know what I mean? And so that's definitely what you want to do. So the last needed abatement petition on the failure of the accused coercive man by his or her proper name, the present, oh shit, hang on. Alright, here we go. So here we have, de facto courts have no lawful power to name natural born people or otherwise exercise jurisdiction over them, except with their tacit, ignorant consent. And so ignorant just means if you don't know, and you don't know what you don't know. Now you fucking know that they can't be playing stupid ass games with live living people. They're corporations and can only fuck with corporations. Really that simple. To date, I have heard no abated accusation being refiled, properly naming the natural man or woman who objected to be held or to answer to a demand against a fictitious person. However, in the unlikely event that an accusation or demand is refiled using a proper name for the second accused, a second petition for abatement would lie against failure to the name of the venue. That's what it is. All these courts are in all capital letter fucking courts because they're fucking businesses. It's like all caps Walmart and shit like that. That's what these fucks do. So then if necessary, a third for failure to name the court. If still necessary, a fourth petition, failure to identify the nature of the parties and plaintiff and defendant. Because they can't be victims. They're all corporations. And so you need to be able to face whoever's making the accusations, right? So if the state is ever charging you with anything, you know, you could ask the state to please stand and state his name for the record, right? The state cannot stand to fucking state his name for the record because you are the fucking state. These motherfuckers are pretending to be the state. The state isn't a fucking thing. It's not fucking tangible. You know what I'm saying? This is how they're fucking, like, they just mind fucking you. That's what it is. Another method was used successfully is the following: send them in proper order. And that's what it is. So, you know, we're running through this book little by little. And, you know, there's a lot of value in knowing this information. And because it's helping you to understand who it is that you are and who it is that these people are not. And that's what you need to know. Because there's a lot of big changes happening now, and so you're gonna be seeing it, and you never know, at some point you may be asked to fucking step up and take a fucking position somewhere. Because I really don't think that they're gonna be last long. So this is shit that you need to know. And for anybody in your family that doesn't want to study law, at least somebody needs to fucking know this shit, or else everybody's gonna get trampled. They're gonna get fucking trampled. So it's chess. Stop playing checkers with these fucking assholes. That's what I got for you for now. Until we meet again.